All right, today we are in the third part of the first lesson of Chapter 3, and we're continuing to talk about the Constitution of the United States. So I'm going to kind of skim through a lot of this information, knowing that we have to kind of go through it in a little bit more detail after the fact as the sections get more specific. So what we're going to talk about is the fact that our country and our Constitution was founded on the symbol of checks and balances in the government, meaning that no one branch of the three is more powerful than the other. With the executive branch of the president, they enforce the laws, they grant the pardons, appoint judges to fill the courts, so they're kind of involved in every aspect. They could call a special session of Congress, and the president is the commander-in-chief and has the power to veto bills. So every one of these branches kind of intercorrelates from that perspective. The judicial branch, down here on the bottom, interprets the laws and presidential actions. The judges, though, are appointed by the president, and they serve a term for life, meaning that they either retire or they will die on the bench. They also interpret the laws and determine the constitutionality of the life of the laws that are presented by the legislative branch. The legislative branch has the power to approve presidential appointments and the authority to bring impeachment hearings in the case of something that's needed. They have the power to also override a presidential veto and control appropriations, which we say they have the power of the purse, the money. They could ratify treaties, and they also declare war. In the same aspect, their check or their balance to the judicial branch is the power to institute new courts and authority to impeach or approve justice appointments made by the president. So again, when you look at the executive branch, the judicial branch, and the legislative branch are all on equal terms and equal footings. We have the most impact, of course, on the executive and the legislative branch because we vote for them every 2, 4, or 6 years, depending on which branch or which portion of the branch. The concept also that's really important that we're going to talk about is the idea of judicial review. In this case, kind of comes from a specific case where judicial review comes through, and it's called Marbury versus Madison. That was the Secretary of State versus the President of the United States. And judicial review is the idea that the fundamental of the United States government, that the actions of the executive and legislative branches of the government are subject to review and possible invalidation by the judicial branch, meaning that if the president does something that's not accurate or the representatives do something that's not legal or lawful or following the Constitution, the United States Supreme Court has the power to stop that action or to find that that action is not constitutional. And it comes from that system that we talked about in an earlier chapter, which was federalism. And this was the power of the governments are distributed between the national government and the state government. The framers struggled to find an acceptable distribution of power within the rights of the states and a sufficient national government, which we talked about before when we talked about the Articles of Confederation. The interpretation was so loose that, we had to figure out where do we have state powers versus national powers. America lives under both national and state governments. So the national powers are to maintain a military, declare war, establish a postal system and set standards for weights and measures, protect copyrights and patents. They share some powers with the states, meaning that both can collect taxes, both can establish different court systems, whether it be a state, local, or else at the national, federal level, regulate interstate commerce, regulate banks, borrow money, provide for the general welfare, and punish criminals. You could have both federal cases and you could have state or local cases. The states have very unique powers themselves. They have the power to establish local governments, set up schools, regulate state commerce, make regulations for marriage, and establish and regulate corporations. So it's important to look at when we're talking about this is the structure of the Constitution. So we know that the Constitution has the first thing that we see is the preamble, and we're going to talk about that in class. It starts off with "We the people." And what this is a statement of purpose. It says the purpose of what this whole Constitution is actually about. We then have all the articles from 1 to 7, which is the legislative, executive, judicial, relations among states, amendments, national supremacy, and ratification. And then, finally, we have our amendments, the first 10 being the Bill of Rights and a total of 27 different amendments that we're going to talk about in great detail. So the first thing is the goals of the Constitution in the preamble. When we read it, the first thing they say was we want to form a more perfect union. And what the purpose of that goal was to strengthen the relationship between the states as part of a union and between the states and the national government as part of the new federal system, one group, one organization. Establish justice is the second goal of the Constitution, and the purpose of that goal was to provide laws that are reasonable and fair, impartial, and make sure that the administration of those laws is also reasonable, fair, and impartial. Number 3, ensure domestic tranquility, which is keep the peace and maintain order within the country. 4, provide for the common defense, and that's to defend against national foreign enemies. Number 5, prevent the general welfare, or promote the general welfare. Allow the states and citizens to benefit from the military and economically from the protection of a strong national government. And number 6 is secure the blessings of liberty. And this means to protect the liberties recently won in the American Revolution and preserve them for generations to come, meaning that we have that freedom, that ability. So how is the Constitution divided? The first thing is the articles, and they're the major divisions. Number 2, there's sections, and those are divisions of an article. And then finally, the clauses, which are the divisions of a section. So it goes from like the whole idea when you're doing notes and you're using Roman numerals to letters. Every part is kind of taking a little bit more of detail from the main pieces in the actual document. So the first article is the legislative branch. Section 1 is what is Congress. And the legislative or lawmaking is the power in a bicameral legislature. And bicameral means 2 houses. And for that we have the Senate and the House of Representatives. The Senate was originally declared by the states. That's also going to be changed with a later amendment. What's going to happen is each state is going to be given 2 U.S. senators. They serve a term of 6 years. And then finally the House of Representatives, which is going to be the Section 2, which is House of Representatives, and those are smaller, more representative of the population distribution of the United States. So each state, based off of population, is given one to start off with, and then having more representatives based off the more population that you have. Pennsylvania right now has 19 representatives in that aspect, and those people are re-elected every 2 years. So they call that the People's House because it's the most closest representative that we have, because we have the most. If we're not happy with what's happening, we have the power to vote them out more frequently. Article 1 is the legislative branches. Section 3 of Ken is the Senate and how they operate. Section 4 is the meetings of Congress. Section 5 is the rules and procedures. And Section 6 is the privileges and restrictions. Section 7 is how a bill becomes a law, which again we'll look at in detail. Section 8 is the power of Congress. 9 is the powers denied to Congress. And Section 10, the powers denied to states. Article 2 is dealing with the executive branch, and that's Section 1, of course, is the president and the vice president. Section 2 is their powers of the president. Number 3 is the duties of the president. Section 4 is the details of impeachment. Article 3 is the judicial branch, and that's Section 1 is the federal courts, Section 2 is the jurisdiction of the federal courts, and Section 3 is treason, because again, thinking out the Revolutionary War, if anybody tried to step up against our government or try to portray our government in a bad light the way we did to England, we'd have to make sure that we have a system in place to make sure that that does not happen. Article 4 is the relations among the states. Number 1 is the official acts, 2 is the privileges of the citizens, 3 is new states, and 4 is the guarantee of the new states. This comes into play, of course, when we're talking about the Civil War, the events leading up to the Civil War, when we're trying to admit new states into the Union, whether they were going to be a slave state or not. Article 5 is the amendment process, and the process, we will talk about this again in detail. Amendments can be proposed by Congress or a national convention. In Congress, it has to be with a 2/3 vote in each house. At a national convention, it has to be called by the Congress at the request of 2/3 of the legislator. Amendments can be ratified by legislature or conventions the same way. An amendment is then added. If it is ratified, it will be added to the Constitution. Article 6 deals with national supremacy. Section 1 is national debt, 2 is national supremacy, and 3 is the oath for government officials. Section 7 is ratification, meaning ratification of the Constitution. 9 states needed to ratify the Constitution, and it was signed on September 17th of 1787, which means this document's around for a long time, and that's what's so great about the Constitution, which we talked about earlier, the fact that it's an ever-changing document. So as times change, we change, our minds change, and we're able to modify it through the amendment process. So, not to go through this quickly, or not to go too quickly, but we are going to have a whole section on this. But the amendments to the Constitution, 1st through 10, are going to be the protected rights that we said that the government, from government infringement, which means our Bill of Rights. This is the contract that we asked for when we were passing the Constitution, meaning that we wanted to have some protection guaranteed by our government. We will talk in detail about a lot of these, obviously things like the 13th Amendment, abolishing slavery, 14th is defined citizenship, 16 is the passage of income tax, which is a big change for us. 17 was provided for the direct election of senators, which I told you in the lecture just a little bit ago, that that's not really how the Senate started off with, but the 17th Amendment is going to say that we directly are going to vote for those senators. The 19th Amendment is going to give women the right to vote. Presidential term limits in the 22nd, and lowering the age for voting people to 18 is the 26th Amendment, and that's going to happen in 1971. So you can see on this list the last, the rules for congressional pay. The 27th Amendment is going to be passed in 1992, which is the last constitutional amendment that we have seen during this time. So a lot to cover, and I wanted to go through this pretty quickly because the next few sections in the book are going to be much more detail-oriented, but this gives you a good broad overview of what we're looking at as this piece of paper, this guiding document, really changes the way we interact with our government, and it provides a contract for how our government is going to interact with us.